Hello, Carla Hartley here. Today I'm going to be continuing my discussion of gray divorce, and I'm going to be focusing on financials again. Um, Today I'm going to be looking at the issue of spousal support and whether required minimum distributions from an IRA can be considered income available for support. This, when I started looking into it, I have known for years it's an issue, and it comes up in cases where we have long-term marriages and people who are either approaching retirement age or are of retirement age and either have or have not retired, who are choosing to part ways. Of course, sometimes it's only one party choosing to part ways, and this is particularly devastating for a spouse who has devoted many, many, many years of their lives to the other party. Um, I want to be very clear here that this is kind of a niche discussion, but it is going to impact pretty much anyone who is near retirement age. And there is not just the age 65 opportunity for a supporting spouse to retire, which of course must be taken into account when you're trying to predict the future of your client if you have the supported spouse, or determine for the party, if you have the party who is doing the supporting in this scenario, are they going to continue to work after 65, or are they going to exercise their right to retire? So the next thing we have to consider, though, is there is going to be a modification at age 70 and a half. At age 70 and a half, the IRS requires that parties begin taking required minimum distributions from their IRAs. Um, this is not going to occur in every single dissolution where people have been married for a very long time, but it's going to occur. And you are going to run across it as an attorney. And if you are a spouse who has been married for a very long time, um, I'm not going to say like Bill and Melinda Gates, because I'm pretty sure that their income flow is not going to require them to worry about, their IRAs. But this becomes a big, big issue with your ordinary middle to upper middle class individual who's got a chunk of change in an IRA. My next discussion on this issue of gray divorce is going to be the importance of distribution of equal in kind income, and I encourage you to watch that, because it also turns on this issue of pre-tax and post-tax dollars. All right, so the required minimum distribution. When you take money out of an IRA, that money has to be taxed. It is taxable income. It's going to be recorded on your tax returns. Now, if one of you walks away with, for instance, an $800,000 individual retirement account, and the other one perhaps takes the house, that is not an equal in kind distribution, but it's a good example of the kind of thing that we do see happening in our practice of law, the area of law in which we practice. Sometimes emotions are making decisions where maybe the math calculator should be making the decision, and the former family residence is often an extremely important emotional touchstone for one of the parties. So here we go. You've got one spouse has $800,000 and the other spouse has the house. So the spouse with the $800,000, let's just say, has chosen to continue to work, and they're making $5,000 a month. But now they have this, because maybe it's just working part-time, let's say, and they've just turned 70 years old, and in the next 6 months they have to take a required minimum distribution. So how are we going to calculate that for support? That is the question. And there is a significant split of authority on this, as I have looked into this for this IRA. We have, or not this IRA, this video. We have the Marriage of Reynolds, which says you cannot deplete an asset in order to support a party. that would seem to imply that the required minimum distribution, let's say they're going to take $20,000 out this year. That $20,000 is a little bit more than $1,000 a month, so it would increase their income available for support, and it would increase the support amount payable to the other spouse if counsel is doing their job. Now, let's just say we look at marriage rentals, and if that $20,000 is not earnings, it's coming from say an IRA that's invested in just a plain old savings account. It's got no interest in the stock market, no big earnings anywhere. So that $20,000 is going to come and just reduce the amount in that IRA to $780,000. Under Reynolds, you cannot count that as income available for support. But then we have a case, Marriage of Olson, which says that, well, you're not just limited to what comes out of one of these things, and all of the gains on this type of an asset would also be income available for support, even if it's not withdrawn. So between Olson saying, okay, let's say the $800,000 was invested and earned another $20,000, and that $20,000 was taken out as part of the required minimum distribution. Under Olson, that's income available for support. Then we have a couple of other cases. There's a case Smith, and then there are a couple of unpublished cases. It's always good to read the unpublished cases because you want to know what the appellate courts in your area are thinking, because trust me, your local judges are wanting to know what the appellate courts are thinking on their unpublished cases. It's always a good line into where things are trending. And I just think this is a split of authority, and it's going to turn on individual facts, and I think you have to have skilled counsel to figure this out. Now, if someone, and I want to very, very clearly state, I read an unpublished case that was upheld on appeal when the trial court provided for the depletion of the entire IRA, which coincidentally was in the amount of $800,000, for the support of the parties, not all at once, but over a 20-year period. The court in that case found the party who had the IRA, I think it was husband, found his argument that he wanted to preserve the principal for his heirs to be unconvincing. Now, this is unpublished. It did not make law. And when I'm talking about it, this is something I could not cite in a court of law. I would be ethically sanctioned for doing so. But this is something that you have got to have competent counsel looking at. You don't want to leave money on the table for support if you are going to see this 70 and a half year number click by anytime in the near future once you are looking at a divorce and you're close to retirement age or at retirement age. And you don't want to just assume one way or the other, because we have such an extraordinary split of authority on this that kind of does turn on facts, and I expect to see more development on this as the baby boomers continue to age out. Because do we deplete the asset? People are living longer and longer and longer. Is 20 years an adequate amount of time to permit this to support these people? What's going to happen at year number 21 when they're both still present and there's nothing left? So these are things to consider. Long-term financial security is always frightening. And when you've been married and in a fixed relationship for a very long time, these things must be considered. I hope I have not frightened you. I hope you find this encouraging. I hope you find this helpful. And I do hope, wherever you are, you reach out to competent counsel who regularly practices in your local family law court to find out how the facts of your case are going to affect you. Good luck, and I will be talking to you again soon.